Good afternoon and welcome to the Appellate Division First Department. We have almost 6.5 hours of argument time requested today, and I therefore have to ask you to reduce your request to what you reasonably need to argue. I point out to you that if the red clock goes off and members of the panel have further questions, we don't stop with the red light. People versus Snow. Submitted. Eltosam versus Darling Ingredients. How much time? 3 minutes. Thank you. Matter of V Children submitted. AT&T Mobility versus Grupo Salinas.
Good afternoon, Your Honor. For the appellant, I will request 10 minutes and divide it into 7 and 3 for rebuttal.
Your Honor, for respondent, will ask for the same total 10 minutes.
7 and 3 and 10. People versus Hicks.
Good afternoon. Appellant request 5 and 3.
5 and 1 and 5. Jane Doe 3 versus Kip Academy. Okay, 5 and 1, 5 and 5. And now both of the Jane Doe 2 versus Kip appeals. For both cases, 5 and 2. Well,
For the Kip Academy respondents,
5 and 2, 5 and 5. Liberty Mutual versus Marado.
Good afternoon, Your Honor. Michael, for the appellant Kip Academy, we request 3 minutes.
Thank you. People versus Rochester. Submitted. People versus Ward. Six and 2 and 5. McPherson versus Pepsi Cola. Submitted. Ortiz versus Montefiore Medical Center. Do you want to submit? Biro versus Adams. Five and 1 and 3. People versus Richberg.
Good afternoon, Your Honors. Appellant request 6 and 2.
Good afternoon, Your Honors. People request 2 minutes.
6 and 2 and 6. Lazar versus Moore submitted. Gullah versus Modern Yak submitted. Eltosam versus Darling Ingredients. Go ahead.
May I begin, Your Honor?
Go ahead.
Yes. May it please the court, my name is Mark Citron. I'm here today of counsel to Robert A. Himes, attorney for the plaintiff appellant. This appeal involves Thank you, Your Honor. This appeal involves a two-vehicle collision that occurred back on April 7th of 2021 in the vicinity of Vise Avenue on Boston Post Road. The defendant owner-operator was a dump truck. The plaintiff was operating a two-door sedan. At that location, the roadway is covered by an elevated subway line, and at that location there is both an inner roadway and an outer roadway. The plaintiff was on the outer roadway, the defendant was on the inner roadway. The inner roadway actually ends at the location of the accident, and the plaintiff was required to merge into the inner lane. The evidence is that the plaintiff, while merging into the inner lane, as he testified, approximately 90% in the inner lane, was struck on the left rear wheel well by the defendant's dump truck.
Counsel, the fact that there was an elevated roadway or the other circumstances you've discussed doesn't change your client's obligation, does it, under VTL 1128, to drive his vehicle as nearly as practicable within a single lane and not move from that lane until the driver has first ascertained that such movement can be made with safety?
Yes.
So none of those circumstances affect your client's obligation under that statute, right?
No, Your Honor, that's correct. My client had an obligation to merge safely into the inner lane, and his testimony
But in
was...
fact, at the time of the accident, he was astride two separate lanes, right?
Yes, he was stopped, and he testified he'd been stopped for about 5 to 15 seconds before there was an impact to the left rear
And
by the dump
he was
truck.
inside the lane in which the truck was driving 90%, is that right?
That is correct, Your Honor. That was his testimony, and that testimony was confirmed by the non-party non-party passenger.
What do you do with the opinion expressed by Lynch that the physical evidence indicates that the Toyota was merging from the service road onto the southbound lane of Boston Road, traveling faster than the truck when the contact occurred? The lack of any damage to the rear of the Toyota further confirms that the Toyota was never in front of the truck prior to the incident, but rather was moving from the service lane into the main travel lane of Boston Road when the contact occurred. How do you get the defendant negligent in the face of that opinion?
Well, from the defendant's testimony, Your Honor, the defendant obviously has the right-of-way, being in the inner lane. But in addition to having the right-of-way, the defendant has an obligation to see what there is to be seen.
But what Lynch is saying there sort of refutes coming to that sort of a conclusion.
Well, Your Honor, we submitted an expert's report, which essentially
I don't think the expert really quite responds to this point of Lynch.
The question, Your Honor, is in a summary judgment motion, as we all know, are there issues of fact and proximate cause? And with respect to this accident, the defendant's failure to observe the plaintiff at any point in time prior to the collision.
Wasn't there a pillar there, a subway pillar, in addition to a side entrance?
Well, there was no pillar where the plaintiff was merging, obviously, because that's the roadway. There was a pillar in front of the place where the accident occurred, and there was a pillar behind. And the defendant stated multiple times in his deposition, I looked, I didn't see anything. And the defendant...
Right, but counsel, right, there's no possibility that your client, I mean, the pictures show, the pictures say a lot, there are a lot of pictures.
Yes, Your Honor.
They show there's no possibility that your client went in a safe manner because his car was hit on the side, which would necessarily have to mean that he was going in at the time the car who had the right-of-way was moving forward. So I don't know how you can refute that.
The points of impact, Your Honor, indicate that the plaintiff was, in fact, ahead of the defendant at the time of the impact. And in light of the weight of the truck...
But not enough so that the truck hit the plaintiff in the back, which means that plaintiff would have already merged, right? He hit him on the side.
The plaintiff
There's
testified...
no way.
I'm sorry, Your Honor, I didn't mean to interrupt.
No, there's
The
just
plaintiff
simply-
testified that he had been stopped because of a traffic signal ahead for 5 to 15 seconds. Essentially, if you can picture, he's stuck in that position. He moves in, he's angled into the defendant's pathway, and he's stopped for a period of time. The defendant does not state or testify that he was aware that the plaintiff was there. The defendant moves forward and hits the stopped vehicle angled in the roadway on the left rear portion, and the defendant's own expert states that the lugs of the right front wheel actually caused the damage that we see. So the defendant's vehicle was in motion, and the plaintiff's vehicle was stopped. And that raises...
Thank you, Counselor.
Thank you, Your Honor.
Good afternoon. May I please the court?
Counselor, you can sit at the table. That's our usual practice. You can. That's our usual. That's our usual practice.
Sorry. Good afternoon. May I please the court? My name is Jack Yao. I'm an associate at Marshall Dennehy PC, attorneys for defendants, respondents, Darling Ingredients Incorporated and Kimoy Winter. Here, defendants met their prima facie burden as movements by demonstrating that plaintiff clearly violated Vehicle and Traffic Law Section 1128. It's undisputed that the plaintiff failed to see the Darling truck prior to the accident.
Counsel, your adversary argued in his papers that the defendant truck driver failed to look out of the side mirror, the side view mirror, and that's why the accident occurred. What would you say?
Well, our response to that would be, given the points of impact, the side view mirror would have only shown the whatever was behind our client. And second, in terms of plaintiff's argument that our driver failed to see what there was to be seen, we believe that he saw everything that there was to be seen.
But if the point of impact is in the rear and on the side, doesn't that kind of lend itself to maybe some interpretation that the plaintiff had entered into the roadway and was trying to continue into the roadway, and the truck driver should have seen that and maybe slowed down?
I think there could be an interpretation that that's what happened.
And then why wouldn't that be enough for a tribal issue of fact?
Well, we do think that there could be an interpretation. We believe that that interpretation is unavailing because, given the plaintiff's testimony juxtaposed against our client's testimony, we submit that it's implausible that the plaintiff would be attempting to merge onto Boston Road, and throughout the entire merger attempt, never once did he see our client's truck.
Isn't the fact of what Lynch says that the damage to the plaintiff's vehicle indicates that the truck had moved forward ahead of the plaintiff's vehicle? That it's plaintiff pulling into defendant's lane of traffic?
Yes, Your Honor. I believe our expert, he opined that at the time the plaintiff's vehicle was the one moving into our lane, that the plaintiff's vehicle was in motion mid-merger attempt. I'm not sure if I misunderstood your question.
No, that was the point of my question.
Oh.
Yeah. Okay, thank you. Thank you both.
Thank you.
Thank you.
AT&T Mobility versus Grupo.
May I proceed, Your Honor?
Go ahead.
Yes, good afternoon. Kenneth Caruso for the defendant appellant, Grupo Salinas Telecom. This case involves 2 tax years, 2013 and 2015. I'll start with 2013. I can state my argument very succinctly. 1, Grupo Salinas did not commit an anticipatory breach of the contract.
The plaintiff asserts that the whole thing relates, however, to prepayments from 2013. Is that correct?
In part, that is correct with respect to the 2015 tax year. Not at all with respect to the 2013 tax year, which is...
It's not so that the 2015 audit relates to prepayments that were made in 2013 and then get challenged by the SAT in 2015?
That statement is so, yes, but the legal consequences are entirely different from what Justice Maisley held. With respect to 2013, she held that my client committed an anticipatory breach. I suggest that that is incorrect as a matter of law. My client retained its right to control the defense of the audits. When AT&T then settled with the Mexican tax authorities, it did so at the time that my client retained the right to control the defense of the audit. By making that settlement, it was AT&T that breached.
But you say we're not taking over, we're not going forward with the SAT, and in fact you tell plaintiff don't submit anything to the SAT until we reach an agreement on an apportionment of who's paying what. plaintiff was entitled to indemnification. Did you have a right to put that sort of a condition on the indemnification?
Well, we didn't put a condition on it. All we did was open up a negotiation, and I suggest to the court that that cannot be an anticipatory breach of contract. My client conceded liability for the indemnification for 2013, and it conceded liability for a portion of 2015, but not 100% of 2015. At that point, my client opened up a negotiation and said, we need to allocate this responsibility. Opening that negotiation is not the imposition of a condition. It's a negotiation, a consensual process in which AT&T participated. I suggest to your honors that opening a negotiation to reduce one's potential exposure in an arm's length relationship is not a breach of contract.
So
It's very
wait a second,
dangerous.
you're saying that you didn't seek any money for the 2013 tax year from the plaintiffs? You didn't seek, you said, we'll pay the 100% in 2000?
In the course of the negotiation, yes, our position was 2013, we're responsible.
And how much were you-
2015, shared responsibility.
Wait, 2015, right? And where did that come from, the 2015 we share responsibility? Where did your position for that come from?
Well, it came from the facts and circumstances.
No, what does the document say about your responsibility for 2015?
The documents
Doesn't the document say that they're entitled to indemnification?
Yes, but how much?
So then why would you even start a negotiation which implies that you don't think that you're entitled, that for some reason, what the document says, which is they are entitled to indemnification, was not your understanding of the agreement?
The document doesn't say they're entitled to, well,
We could read it together if you like, but, all right, let's just assume that I disagree with you.
yes, my point is that under the circumstances, which included AT&T unilaterally beginning to defend the 2015 audit, and thereby suggesting that AT&T had some responsibility for that and knew that it had some responsibility for that, there's absolutely nothing wrong with my client saying, I'm not going to pay 100%.
But what does, as my colleague is, I guess, highlighting, in section 7.5A of the SPA, doesn't it use the language all when it's talking about indemnification?
But it depends on the facts of the case. Just because the party, the indemnity, says, I want 100% of both tax years, that doesn't mean that my client has to automatically roll over and play dead and
But
say,
there's no
sure.
question, is there, that for 2013 you were supposed to indemnify?
Well, yes, and we conceded that we would, but it was part of a negotiation, and therefore, once you have,
I
Why are
don't
you
understand what that
negotiating about
means, yeah.
something which you concede you owe?
sorry, I don't know which question. to
Why are
answer.
you in a negotiation about something which under the contract you're conceding that you owed?
We didn't concede that we owe it.
For 2013?
We did concede that, but the 2013 and 2015 were audited and discussed together and resolved together. Both sides put the two audit years together, not surprisingly. So our position was, okay, we're liable for 2013, but we're not liable in full for 2015. And we, in an arm's length relationship, we had every right to say, we're not 100% responsible for 2015. I mean, the holding that opening a negotiation is a breach of contract is commercially extremely dangerous, extremely dangerous. If a business person has
No, but let me ask you this. If saying, oh, yes, the contract says I'm entitled to 100% indemnification, and you saying I'm not going to indemnify you 100%, you're saying that that's not a breach of the contract?
I am saying that's not a breach of the contract
Okay.
under the circumstances, which include AT&T taking responsibility for the 2015 tax year. It is not, my position, let me be very clear. My position is, as a matter of law, opening a negotiation,
You can say what you want. If the document says you have to indemnify and you tell the other party you are not willing to 100% indemnify, you can massage it however you want. That's a breach of the contract.
it depends on the facts.
Okay, fair enough.
Thank you.
Thank
You have time in response.
Uh,
You have time in response.
Thank you, Your Honor.
Thank you.
Good
Good afternoon, may it please the court. Adam Abinson for the respondent, plaintiff AT&T. Your Honor, there was no negotiation. In the words of Justice Masley, there was a holdup. There was an effort to extract money by Grupo that it was not entitled to under the plain terms of the SPA.
What's your position as to 2015? Obviously, you've had a trial and you've prevailed, but at the outset, what was your position as to 2015 as to what you were entitled to be indemnified?
Your Honor, under the plain language of 2015, I'm sorry, of the stock purchase agreement, the SPA, AT&T was entitled to full indemnification across tax years. The language of the provision, 7.5, provides that we are indemnified for any damage, quote, relating or attributable to a pre-closing period.
Is that because the prepayments were made in 2013 and the 2015 relates to those prepayments?
Exactly, Your Honor. And we heard counsel concede that all of the liabilities across tax years related to that 2013 prepayment. And in fact, a parade of their own witnesses at trial conceded that the 2015 liability related to the 2013 prepayment. Their outside Mexican counsel, Mr. Arias, at A4652, said they were, quote, interrelated. Their consultant, Mr. Flores, at A4882, said, quote, they are related. Their head of tax litigation, Ms. Vargas, at Respondents Appendix 40, said they, quote, related directly. This is a direct hit on the contract language. They are
Counsel,
obligated.
let me interrupt you for a second just to ask you, please, what was defendant's position at trial as to why they weren't responsible for the payments?
As far as I understood, Your Honor, the position in effect was that we had swooped in and taken control over this settlement process from them, which is the same factual premise they rely on today in this appeal. The problem with that factual premise is that the court, having heard 2 weeks of witness testimony, having made credibility determinations, rejected that factual premise.
Based on the facts and the law, or simply?
That was a factual determination,
Factual
Your Honor,
determination.
based on overwhelming evidence. And the court reiterated this fact finding repeatedly, starting at A5139. Justice Masley noted the Grupo was participating to the end. At 5141, quote, AT&T did not usurp control of the audit defense in June 2019 or ever. At A5147, clearly, Mr. Isu.
Aren't both sides involved in the defense of it? Don't both sides retain Arias to work for them on the different years?
Yes, both sides had the same counsel, and it was the testimony at trial that Grupo was directing the process. Ms. Vargas testified to that. Mr. Isusi, the head of tax at Grupo Salinas, testified to that. In fact, the way this worked is because these audits were so closely related, because they involved the identical prepayments that Grupo had made before we acquired these companies, Grupo was controlling the defense. Their witnesses said so. And we were following their lead. And their lead was to settle this. And the court had overwhelming evidence of that, and it's a long list. It was Mr. Brago, their general counsel's testimony, that Grupo made the decision to seek to settle. That was at A4450. Grupo helped prepare the settlement proposal that the SAT ultimately accepted. That was Mr. Isusi, their head of tax, at A4343. Grupo's people attended the meeting with the SAT where the terms were agreed. That was Mr. Arias, their outside counsel's testimony, and he said, by the way, that he was there on behalf of both companies, and it was their consultant, Mr. Flores. Mr. Arias said it at A4714, Mr. Flores at A4928. Grupo's personnel helped prepare the paperwork finalizing the settlement. And counsel's position is, at some point we swooped in and took over, just after that meeting I mentioned. This testimony concerns events after that. After they sent this email that Your Honor alluded to saying, let's stop, let's put the brakes on it, by their actions, they weren't putting the brakes on anything. They were still moving this towards settlement. We had testimony from Mr. Flores at 4986, from Ms. Vargas, their head of tax litigation, at RA65. They also, Mr. Isusi, the person who sent the email saying we no longer want to settle, after he sent that email, he testified that he was tinkering with the language of the final agreement to make sure it created protection for Grupo against liability under Mexico's VAT and flat tax, several $100 million in liability. That was his testimony at A5138. I'm sorry, at A4548. And Justice Masley found that especially important to her factual conclusion that they in fact retained control and wanted to settle.
Counsel?
Yes.
How do you respond to your adversary's allegation that Grupo Salinas is liable only for a portion of the 2015 monies that were paid?
It's simply not what the contract says. The contract says they are responsible for all liability relating or attributable to any pre-closing event.
It's your position that all of the liability relates back to 2013 and there's nothing separate and apart and new?
It is our position, but more importantly, it's the testimony at trial and it was the court's findings. I recited earlier a number of the Grupo witnesses who said, yes, everything in 15 related to 13. The way this worked is Grupo made these large prepayments that created a large net operating loss. Those losses offset all the income for 13 with losses left over that carried into 14 and 15. The liability in 15 was because the SAT rejected the loss.
Right.
So there was no additional amount. All of their witnesses recognized it was all flowing from those prepayments in 13. Under the contract's clear terms, that was their obligation. And counsel talked at length about we were negotiating. First of all, they don't get to negotiate. There's a contract that defines their responsibilities.
So let me ask you that. When defendant came to you and said, we only want to pay certain amount of money and we don't want to indemnify, was there testimony about how your client perceived that conversation?
Yes, we had testimony from Ingrid Bergman. I don't have the record site.
Not the Ingrid Bergman.
She likes to keep private, but we got her out in trial. And her testimony was that when they made that quote-unquote offer, AT&T perceived it as a strong-arm attempt to make AT&T pay something it had no obligation to pay under the agreement. There was no negotiation. AT&T understood it was entitled to indemnification. It proceeded on that basis. The settlement concluded on the terms Grupo had proposed, negotiated, and approved. I had read some of the testimony making clear that Grupo controlled the settlement process to the end. I left out the best one. Their outside counsel, Mr. Arias, at Respondent's Appendix 286, was asked, question, so you were authorized by Grupo Salinas to do every last thing that you did to get the conclusive agreement finalized and signed? Answer, yes. It's a head-scratcher how their position here on this appeal can be that we took control from them and settled this over their objection. Their own outside counsel testified that Grupo authorized him to do every last thing, quote, that he did to complete this deal. Now, the only point counsel made, counsel ignored all the evidence I've recited, including that quotation, and says, well, there's no anticipatory breach. Two problems. One, there doesn't have to be. If we didn't take control, there doesn't have to be an anticipatory breach. If we didn't take control, they're responsible under the express terms of the stock purchase agreement to indemnify us. If we did take control, if for some reason the court were to disregard Justice Masley's factual finding, supported by evidence that we didn't, but if we did take control, there's an anticipatory breach. There are two modes of committing an anticipatory breach. You can disclaim your obligation under a contract, or you can take an untenable interpretation of a contract. They did both. They sent us correspondence that said their final position was they weren't paying but about 25% of the total settlement.
That was their offer, to pay 25% of the settlement?
I believe it was in the range of 25 to 30%, Your Honor. And another finding Justice Masley had, by the way, was this notion that they were all acting in good faith and they were calculating what they really thought was 2015 and 2013 was false. Justice Masley found that, in fact, they had manipulated the numbers and backloaded.
Thank you.
Thank you, Your Honor.
Your Honor, counsel said there was no negotiation, but I would like to point to two sheets of paper in this record that shows that there certainly was a negotiation. On June 17th, my client sent an email to AT&T, that's A2878, proposing a 33-67 split. A week later, AT&T wrote back and proposed its own share.
The converse, basically the converse.
Yes, basically the converse, and saying that they would accept that in full satisfaction of my client's liabilities.
Why wasn't that an offer that you couldn't refuse, understanding that 7.58 of the SPA says all, shall indemnify for all taxes and damages relating to any taxes that are relating or attributable to any pre-closing period?
The point is, the parties entered into a negotiation, both sides. It was consensual
Are you
on their
answering
part.
my question, counsel?
I'm sorry, Your Honor, I thought that was an answer, but please forgive me. Perhaps you could put it to me again?
What gives you the authority to, if AT&T said to you, we're gonna do a different split, isn't the very fact that there was an offer to split the amount of liability, or the amount of damages that you would have to pay, wasn't that an offer that you couldn't or shouldn't have refused?
Well, we would have continued the negotiation had they not settled with the Mexican tax authorities.
So you said your client said yes, and AT&T went ahead anyway? AT&T made you an offer, and you said, yes, I'll accept that offer, and even though you said yes, they kept going?
We didn't say yes. We went back with another counterproposal. And while that negotiation was ongoing, they settled, thereby taking away our right to control the audit. The fact that there was a negotiation is indisputable. And the idea that...
Didn't they have a right to assume and control the defense of the tax claim pursuant to 7.6D?
No, they had no right to take control at any time. The control right was with my client.
Does prejudice figure into this?
Only with respect to the 2015 tax year, not with respect to anything that we're talking about so far, right? And just sticking with what we're talking about so far. I just want to...
Isn't the deal that AT&T made with the SAT basically the deal that had been on the table all along and a deal that you participated in formulating? Isn't that what Juan Matos testified to?
Yes, my client participated, but before my client agreed, AT&T went ahead and settled. At the time of that settlement, my client still retained the right to control the defense of the audit. And by making that settlement...
Perhaps we have difficulty with that premise because the 2015 liability stemmed from, in other words, related back to the 2013 prepayments.
Again, the parties negotiated in a way that shows that we weren't liable for entire 2013 and 2015 together. The facts of the case belie that argument. There was most definitely a negotiation. Please just look at those 2 sheets of paper that I cited, and it'll be clear that there was a negotiation.
Thank you. Thank you both.
Thank you very much.
People versus Hicks.
Hi there. Good afternoon, and may it please the court. Paul Anderson for the people. So this case involves 3 well-established exclusions to 2 adjournments in terms of 30-30 time. The first being the 30-30 4G exceptional circumstances exclusion for an unrefuted medical leave. The second adjournment involves 2 exclusions. One, the...
Also, the NYPD surgeon indicated that the officer was out and unable to testify. But he had some kind of broken appendage, right?
It was a broken ankle, and he was out from essentially from October 22nd till December 24th. And we agree that after he returned to duty on December 24th, we're not entitled to that exclusion. However, that broken ankle and being on medical leave, this court has repeatedly found in the Court of Appeals for decades that that is enough to trigger the exclusion. And we don't have to go the extra step of he was hospitalized or completely immobile. Al-Sakar says that explicitly, as does, which was a back injury. Celestino also says that explicitly, which was a broken leg. And then we have Hernandez and Chambers, also from this court, which involved broken ankles. So here, there really wasn't a basis.
In that Hernandez case, the officer there did have a broken ankle, but there was something further that he was unable to walk. Was there any kind of representation such as that here?
Not in this case, Your Honor. Yes, in that case, there was extra, yes, but that's still not the minimum floor. And this court has rejected specifically the type of argument made here that you have to go so far and say that he's immobile and can't come in, or which in Al-Sakar, that was explicitly argued and addressed. In Celestino, it's addressed in the opinion that the court has never gone so far. And if we go back to
So,
Goodman from the
counsel,
court-
is it your argument that it's enough that his surgeon said he can't come in?
Yes, it's the NYPD saying
medical,
this
right?
person is too infirm to work. Had he been able to come in on limited duty, I agree then. If he's able to come to a desk, he's able to come to court.
And that evidence was before the court on the day, or at the time of the hearing, correct?
At the motion, we submitted that documentary proof. But going forward back to Al-Sakar and
Is that the
Celestino.
email from Robert Federa?
Yes, the email from the agency counsel saying that I can confirm that based on medical reasons, he was with a broken ankle, he was out for these dates, can't go anymore without a HIPAA authorization or a subpoena. And we shouldn't have to go that far because that would delay the process more. And in Celestino and Al-Sakar, it was actually just the ADA's affirmation of speaking to the officer that, yes, he was out of duty. So here, we have all these cases, and it was error for the court below to not really address them or say that we had to do more when going for decades, this court and the Court of Appeals back in Goodman has said that this is enough. And so if Your Honor, I guess if you want to address the other exclusion, the motion exclusion, they asked for a motion schedule. 4A says as soon as they ask, we're entitled to it. And in addition, Liability recently from the Court of Appeals, that was time in addition based on court congestion. So if Your Honors have no questions, I'll just save my time for rebuttal. Thank you.
Your Honors, good afternoon. Kathy Liu, Center for Appellate Litigation, representing Mr. Dequan Hicks. My adversary says that it's well established that proof of medical leave alone can satisfy 4G. This court has never held that, and the Court of Appeals have never held that.
In our SECID, it says the people were not required to show that the witness was completely immobilized or totally incapacitated, or that they had made extraordinary efforts to secure this presence. You
Yes, Your
disagree?
Honor. Yes, it does say that, but we're not asking for
No,
a
not
showing
the
of.
but. Do you disagree with precedent?
No, I don't. But the distinction here is that we're not asking the prosecution to show complete immobilization or hospitalization. We're just asking this court to hold the prosecution accountable to the standard it has articulated in McLeod and Colestino.
That's saying that I've evaluated this person, they are unable to testify.
So-
Are you asking us now to hold or to put this out there that when an NYPD surgeon states that this officer is unable to testify, they're out in the line of duty and they're unable to testify, that we need to now put an additional layer of proof for the court to recognize that?
So, Your Honor, I think what you're referencing is the fleeting reference to a, quote, notice from the police surgeon indicating that he cannot testify at that time. But the prosecution never provided a copy of this notice to the court. We don't know what it actually says. It could very well say, he can't come to work. The prosecution just represented it indicated that he couldn't testify at this time. So we actually have no idea what the substance is.
Is it a great leap of faith to believe that someone who's got a broken ankle is not readily able to appear in court to testify?
So the only thing that we can infer from his medical leave status for a broken ankle is that he cannot perform the day-to-day duties of a police officer.
So, counsel,
But he had already been on, I'm sorry, Your Honor.
I'm looking at People v. Bailey, 1995, also from our department, where it said the people made representations to the motion court based upon information provided by correction officials that this adjournment was the result of defendant's hospitalization for an eye injury, and I'm jumping. The representations constituted sufficient proof of defendant's medical availability, and the people were not obligated to prove it by any other means. So that's a representation of unavailability by an officer of the court. And here we have a representation that the district surgeon, I believe, of the NYPD said, this guy can't testify.
Yes, I'm happy to address that case, Your Honor. In that case, it was unrefuted. That representation was unrefuted. But here, both the defense counsel and Judge Samaj refuted.
How?
How did they?
Because
They
What
had no
evidence-
independent information. Neither defense counsel nor Judge Samaj had any independent information about the potential witness's medical condition, right?
Well,
So how
Judge
could they
Samaj
refute
said
that?
A broken ankle does not prevent the witness
That's not
from
refuting
coming
it,
and
that's
sitting
stating
in
an
a chair.
opinion about the evidence that was tendered to her. Was there any actual evidence tendered that refuted it?
Well, no, because this is the prosecution's witness, and this exactly shows why it's the prosecution's burden to show why he couldn't come into
So a
court to
broken
testify,
ankle
and there's
doesn't,
nothing
a
here.
broken ankle doesn't count in your view.
Well, I also would like to remind the court that wasn't a fresh ankle. He had been on
your
medical
pardon?
leave since October 23rd, so he had already been in recovery for 3 weeks. We don't know how
So it's
severe
your
it is.
opinion based on what? That a person who's been recovering from a broken ankle for only 3 weeks is capable of testifying in court, notwithstanding the position of a doctor, district surgeon from the NYPD, that he cannot testify until December 25th. Please.
Yeah, respectfully, Your Honor, I think that question is premised on shifting the burden of proof. So it's the prosecution's burden to show why.
You
But
want a
when was it-
wheelchair? You want crutches? What do you want? You want a boot? What is missing what is missing here?
There is no information in the record as to how severe the injury is or why October couldn't come to court. We don't know if it was a minor fracture. We don't know his level of mobility. We don't know his level of pain.
So can we
And
turn
in
to-
all of the cases that we cited
Can we
to-
turn to the other 10 days at
Yes.
issue? Given that on the last date at issue, defense counsel stated his intention to make a motion, why shouldn't we exclude that 10 days?
Yeah, so for that period, the record states that, well, the court specifically told the prosecution to file a new statement of readiness when they were ready.
But
And
in
then after
addition,
that,
defense counsel
said
stated there,
I'm sorry, Your Honor, I didn't mean to.
but defense counsel stated his intention to file a motion. Doesn't that override the other?
No, because it was a tentative and conditional
We must have been
intent.
reading a different
He said
record. I didn't
if-
see any of it as tentative.
Yeah, this is on pages 3 to 4 of the January 10th calendar call, and I will read it to you, Your Honor, if that's helpful. So the court directed the prosecution to file a statement of readiness, and then defense counsel said, if the people file a statement of readiness, then I will file a 30-30 motion, and the court then sent a tentative briefing schedule. So everyone understood.
May I, oh, go ahead. Did the people file a statement of readiness?
No, they did
So,
not.
and yet and yet the defense, so your view is that it was tentative, but the facts show that counsel was filing that motion.
I understand, Your Honor, but it was the understanding of everyone in that courtroom that the people were still responsible for filing a statement of readiness, and they would be charged time until they did so. And so it was reasonable for Judge Samaj to charge them with this time based on everyone's understanding until a motion was filed, which conclusively triggered 4A.
Thank you.
Thank you.
Your Honors, I think you have all the arguments here. I have nothing to add unless you have any questions.
Thank you, thank you, thank you both. Jane Doe 3 versus Kip Academy.
May it please the court? Deborah Cohen for Plaintiff Appellant Jane Doe 3. I will assume, unless the court requests, that you have a knowledge of the facts underlying this.
Definitely.
Yes, Your Honor. Apologies for the record. This is an appeal of a grant by the court below, full grant of the motions to dismiss of two sets of defendants in this matter. I'll call them collectively the Kip New York defendants and the Kip Foundation defendants.
Counsel, I have a question as to specific individual defendants, Myers Ruiz, and Brenner, what are the specific allegations for those particular individuals? Other than the brief statements in the complaint that they might have been co-principals, because I think I'm a little bit confused as to the timing of when they became co-principals as it relates to this specific incident.
I can relate to the court's confusion, if I can use that word. For those three defendants, I will acknowledge that from our research that was done on background in drafting the complaint, that we had less direct information from the outside information that we...
Or maybe no or at least none that was pled in the complaint, right?
Well,
nothing was pled in the complaint.
part of what the challenge was here.
100%
Yes, I
understand,
acknowledge that, Your Honor.
right? But
I would add to that, that as is always the challenge with a CVA case, we were dealing with a plaintiff who was a child being abused many years ago, who recounted certain information to us based on her best recollection, and then, so the direct allegations in regard to some of the individuals that you reference are attributable there. But I agree with Your Honor, certainly, that it may be that if we had access to the documents that we have not had access to, that apparently were serving as the basis for the averments that were relied upon by the court below, the affidavits relied on by the court below, it's very possible that some of those individual defendants might be dismissed.
well, but I mean, you're the one who you're the one who brings the complaint, right? It's not up to the defendants to give you the information. You have to have some good faith belief, right? Can't just say it. You have to have some factual allegation. And with respect to two of the defendants, you definitely do, right?
Correct.
Levin and Corcoran.
I would say three defendants in terms of, but if we include the foundation defendants as well as the
I'm
academy.
only talking about, I'm sorry, I'm just talking about the individuals. I should have been clearer, I apologize. Those two, you actually do make specific, at least some factual allegations, but there are no factual allegations with respect to the other three, and you have to have some good faith basis for your allegations, right?
I have no interest on behalf of plaintiff to engage in argument or discovery.
So what are your allegations as to Levin and Corcoran?
What, I'm sorry, Your Honor, you say
What
what?
are your allegations as to Levin and Corcoran?
Levin in particular was a co-founder of the Knowledge is Power program in 1994, prior to any charters officially going into effect for the program in New York City. He, along with Defendant Feinberg from the foundation, created the unique policies and procedures, the unique educational principles, the unique disciplinary approaches that are the underpinning of the Knowledge is Power program. He came to New York, we allege, negotiated with the Department of Education to create a KIP program within a Bronx public middle school. We allege that Mr. Levin with Mr. Corcoran both moved to New York, recruited students for the program, ran the program, hired the teachers, or identified the teachers who may formally be employed by the Department of Education. We don't know. We haven't seen the paperwork as to what the contractual obligations were.
And you still have the DOE in. There's no doubt, right? At that time, they were DOE employees. Right. And you have the DOE in.
Correct.
Okay.
The DOE was not dismissed. If I can just finish answering Your Honor's question. What this is boiling down to is the dismissal based on the documentary evidence that was produced. The court below essentially found that documentary evidence was sufficient to decide without any dispute, factually decide, that only the Department of Education had a duty to Jane Doe 3.
So, counsel, given the fact that the allegations concern the period of 1995 through 2000, and I believe the students graduated from school in June of 2000, I would imagine. The school year doesn't, the school year ends in June.
Well, the KIP calendar operated then and continues to operate on a separate schedule than the public school calendar for the city of New
Did you indicate that
York.
in the papers?
Excuse me?
Did you indicate that in the complaint?
Yes, Your Honor. In fact, I believe we included a copy of the schedule.
So to the extent that the Kip Academy was incorporated in September of 2000, and Kip New York was incorporated in December 2005, I'm going to put the foundation aside for a second. It's your position that even though they were incorporated after the graduation date of these children, they're liable?
That's our allegation, yes, Your Honor.
Backed up by what?
Backed up by the fact that Kip Academy, which became officially chartered as the Kip Academy Charter School in September of 2000, was operating from 1995 until September of 2000, separate and apart from the public school in which it was housed, and that Mr. Levin and Mr. Corcoran and Mr. Feinberg, who was at that point still based in Houston, were Mr. Levin. I'd like to focus on Mr. Levin. Mr. Levin and Mr. Corcoran were.
At what point does the liability of the Department of Education end? Is it in June 2000? In your view?
In my view, likely September of 2000, although with charter schools, it's always somewhat confusing, but it's clear that at the very least there is shared responsibility, because our allegations, and I think the court will agree they're quite detailed, that it was Mr. Levin who was on the premises, who was supervising the facilities, was supervising the teachers, and who was making sure that the unique curriculum and the unique disciplinary policies of KIP were in fact being effectuated by the teachers. And
In your view, the KIP program that was run under the Department of Education is the same as KIP Academy and KIP New York and KIP Foundation? It's the same thing?
Yes.
The fact that there's a designation as a charter school and they have a separate legal identity doesn't make a difference?
Your Honor, corporate formalities do matter. And we're in no way suggesting that corporate formalities should be ignored in this case, but there certainly are exceptions to the logical rule that corporate liability attaches when the entity is officially or formally formed.
But counsel, what allegations did you make in the complaint to establish that there would be any liability on behalf of the corporations formed after 2000 for events that occurred before they were formed? I didn't see any allegations in the complaint that would establish a basis for imposing liability on these corporations, which, as you concede, were created essentially after the plaintiff graduated from the school. What allegations tie these corporations to events that occurred before they were created?
The intertwined identities of the individuals who were operating the KIP program before the charter officially came into being. We think that once we're allowed some basic discovery in regard to the agreements between the DOE and the KIP program, as well as access to personnel files and other relevant information, that we will be able to establish on a theory of successor in interest, for example.
Thank you. Thank you. You have time in response.
Good afternoon. May it please the court. I'm Sarah Thompson. I represent the respondents, Kip Academy Charter School, KIP New York, Inc., and the employees of Kip Academy Charter School. named as respondents in the briefs. With respect to,
Corcoran's your client?
yes, that's correct, Your Honor.
What's your position why Corcoran should not be in the case?
Your Honor, the affidavit that was submitted by the head of human resources in our motion to dismiss below indicated, and I don't think that the allegations dispute, that Mr. Corcoran was a principal of Kip Academy Charter School once it was chartered.
But that affidavit didn't establish that the affiant had any personal knowledge. It was all based on documents which were not produced, correct?
It was based on her review of the employment records.
Right, but those employment records on which she claimed to be relying were not produced to the court, correct?
That is correct. The
So there was
dates,
nothing,
she provided
so why
dates.
isn't it just hearsay?
Well, she provided dates, Your Honor, with respect to...
The dates don't overcome hearsay, do they?
I think they do in a situation where the individual has affirmed that she reviewed records.
Well, let me ask you this question.
Which record she reviewed.
How could plaintiff possibly rebut that or answer that without discovery if they don't have the employment records? If you're not providing the employment records to support the affidavit and they don't have access to the employment records unless there's discovery, why are you entitled to dismissal at this stage?
Well, Your Honor, the records that were provided go back, the crux of, or the foundation of that question goes back to the issue of the charter of the academy. So it's a bit like putting the cart before the horse, because if there is no academy, there is no employee of the academy. So what the documentary evidence and the affidavit jointly and what the court below found, and again, based on the complaint and the allegations actually made, are that collectively those things demonstrate there's no Kip Academy charter school at the time that the abuse occurred, which Your Honors have
Does it matter
understood.
that they're also alleging some sort of successor in interest identity?
It does, Your Honor, and I think we would rely predominantly on what we've cited in the brief, but I think there is a formalistic requirement under New York law. The Court of Appeals has often held that the formal requirement of filing with the Department of State it has to be done. There's no question. It's the red line, so to speak, and in this case, we know that neither of the corporate defendants did that until the dates that we've averred.
Let me just say, so sure, you've got the documents for the corporate defendants, but for the individual defendant, you only have an affidavit that's not supported by documentary evidence, and we've said a million times, an unsupported affidavit, which is untested, you've got the burden. That's not sufficient. We've said it 100 times. You can't do that. That's not enough. Maybe after discovery, we will all agree that the documents show that that person was not employed. But it's not sufficient on your burden to just have an affidavit of someone who said, I looked at documents, right?
Your Honor, again, I would argue that the question of their employment, you can't have an employee if you don't have an employer. And the reality, the allegations, and the documents submitted are very clear, and plaintiff provides...
But how do we know that he wasn't involved in some other capacity?
Well, we
know
know that these defendants were involved in some capacity because it's alleged. They were teachers of the Department of Education.
Exactly.
So why wouldn't they be but the issue then is whether they're personally liable, and the fact that your corporations didn't exist then doesn't relieve them of personal liability if they did something wrong during that time, right?
Your Honor, I think that the way that the complaint is laid out, that is exactly what plaintiff has alleged, that these individuals in their capacity as Kip Academy Charter School employees
that's not how I read it. I read
liability.
it that they, in their capacity as employees, wherever they were employees in the 1995 to 2000, engaged in wrongful acts, and whether or not they were employed by your client at that time or by the DOE, they could still be personally liable. I don't see how your argument, excuse me, I don't see how your argument about when the corporate defendants were formed relieves those individuals of liability if they were employed in the school where the child was a student during the relevant period.
Well, Your Honor, the allegations are negligent hiring, negligent supervision. So if the individual defendants can't hire, can't supervise, which is what plaintiff alleges, she doesn't allege individual liability, a negligence theory based on individual liability. She alleges negligent hiring and supervision.
From your perspective, between 1996 and 2000, where was Corcoran?
Corcoran is a teacher with the Department of Education, and he's not hired, of course, by the charter school because it wasn't a charter school.
But that
Charles
doesn't mean he couldn't
Randall,
have-
in
That doesn't
addition,
mean he couldn't have supervisory or hiring responsibilities with regard to other teachers in the school, right?
Your Honor, that is without our purview because he was a Department of Education employee. That's for the Department of Education to answer to. The reality is that
But that may relieve the corporate defendants of liability, but it doesn't necessarily relieve him of individual liability, right?
Your Honor, I think that it does because the allegation is that Mr. Corcoran was the principal at the charter school when it was a charter school.
So let me just make sure I understand correctly. The Department of Education, which is a part of this case,
Correct.
in the complaint, the plaintiffs aren't alleging their individual liability under some sort of negligent action in their capacity as DOE employees. It's in their capacity as charter school employees, which is why if the charter school didn't exist at that time, there's no liability. It doesn't matter. They could have and they should have maybe done it both ways as employees of DOE and the charter school, but they didn't.
That's correct, Your Honor. And I would also just add to that whether these individuals were involved or what their role was at the Department of Education would be for the Department of Education to speak to. But what we know is that what's alleged, and Charles Randall is the person that's at issue here, right? He's the alleged abuser. Charles Randall, and it's alleged at length in the complaint, was a longtime teacher, 40-something years, of the Department of Education. When he was involved in the KIP implementation of this curriculum, which again, I think it bears repeating, this is a document, a curriculum that the Department of Education was implementing with its students in its building under its guidance. It had the ability, it had the knowledge. If it knew that Randall was a child sex abuser, then certainly that's something that the DOE should be held to account for. But it doesn't speak at all to
I want to
my
make sure
defense.
I understand your position as to Corcoran, that Corcoran may very well belong in the case as a City of New York employee, but in terms of the way he's pled in this case, he's put in as an employee of KIP. And KIP comes on the scene after the time of the alleged sexual abuse.
Your Honor, I would go a step further. I agree with that, but I would go a step further and actually say, I guess I should say I slightly agree with that. I have one small disagreement, which is that I don't necessarily think Corcoran, if he had been alleged as a DOE employee, as Randall has been, would be liable, because I think the nexus between the allegations of abuse have to do with his supervision over Randall, and that actually is not fully fleshed out in the allegations. And I would suspect that as a teacher, it's sort of common knowledge that a teacher doesn't have supervisory responsibility over another teacher within the Department of Ed. Again, that's outside of this.
Your central point is that he's allegedly in the case because of his relationship to KIP.
Correct.
You say that came about after the time of the allegations of abuse.
His role as a supervisor at Kip Academy Charter School
Comes
is what
about
is
after.
alleged.
Thank you.
Thank you.
May it please the court, Dean Pillarella for defendants Kip Foundation and Michael Feinberg. Your Honor, we've heard my adversary speak about successor liability, and this court has said in the WorldCom case, which we cite at length in our brief, that in order for there to be successor liability even applicable to a case, the Schumacher exceptions have to be pled in the complaint. This court said that in WorldCom. The Fourth Department recently said that in KO versus YMCA of Buffalo, another CBA case involving a 3211 motion. The Fourth Department said, because you don't allege any facts supporting a de facto merger, the successor liability theory for discovery doesn't apply. That's plaintiff's whole theory of discovery. It shouldn't apply under this.
So, counsel, may I interrupt you for a second and just say, let's assume we agree with that. But
Okay.
what about Feinberg? Was he involved prior to, are there any specific individual allegations about him supervising or hiring the alleged abuser prior to the foundation?
Absolutely not.
None.
Absolutely not, with respect to Feinberg. And in fact, as we've spoken about in our briefs, plaintiff's entire theory of liability really is not cognizable because it's not based upon prior notice. It's this ephemeral theory that the policies that were purportedly enacted were inadequate, but this court has held repeatedly that whether even if we consider it some form of negligent training claim, it's contingent upon prior notice. It's not alleged. I'd like to back.
When did the foundation came into existence 5 years after the plaintiffs graduated?
April of 2000.
And, okay.
And I'd like to point out that
In April of 2000?
Oh, I thought the foundation?
foundation
When was the
was
foundation?
incorporated in April of 2000. The Kip Academy, which forms the sole nexus that my clients could possibly have in this case, itself did not exist until September 2000.
Okay,
Are
right.
there any allegations pertaining to the 3-month overlap between graduation time in June and?
June through September. So no specific allegations in the complaint. And in fact, this isn't I saying this is in the complaint, that during this entire time, plaintiff was attending a DOE school. The program, the so-called KIP program, was a DOE program. It's in the complaint that the foundation was founded for the purpose of supporting the academy. That's in the complaint at paragraph 13. Academy didn't exist till September. So based on all of that, our primary position is we don't even have to get into the documentary evidence, the affidavits. We could just look at the complaint itself, which in fact the lower court did actually say, I believe on page 2 of the order, irrespective of the extrinsic submissions, it's in plaintiff's own complaint that this is a DOE school, DOE program. So there's just, in our view, there's just no possible basis for my clients to be a part of this case. And again, just to reiterate, plaintiff's whole theory of liability is this theory that perhaps there was a predecessor entity, perhaps there was a successor entity. She says that she should get discovery on that, but that runs afoul of this court's decision in WorldCom, which holds that Schumacher's exceptions have to be pled, and the default rule is that there is no predecessor liability absent sufficient pleading. So the court should respectfully affirm with respect to my clients.
Thank you.
Thank you.
I'd like to start in.
So just to take you back to it, what in your view is the reason that Corcoran belongs in the case?
Corcoran, as it's alleged, Corcoran came with Levin from Houston to New York in 1995 to create the Knowledge is Power program. The program began, it was housed in a middle school of the Department of Education. Corcoran worked hand in glove with Levin to fine-tune the program.
Did he work at the school during those years?
That's our allegation.
And that's what's alleged in paragraph 22 of your complaint, I believe, that he was that he was engaged in founding and managing the KIP program before it became the Kip Academy.
Correct. That he and Mr. Levin actually went out to recruit the students who would participate in this separate program that was housed within the public school. And he was a teacher, and he and Mr.
Counsel, may I
Levin.
interrupt you for just a second and ask you, so your allegation is not only that he was connected to KIP Academy, but that he was there at the KIP program since 1995, is that?
Correct. I think this, in terms of the totality of the complaint, and even looking at.
And he was employed at the school?
Excuse me?
He was actually employed at the school during those years?
He was employed at the school. What the relationship was, the contractual relationship between the Department of Education and KIP was at the time, we don't know the specifics yet. Those documents, that knowledge, are strictly in the hands at this point of the Department of Education, and by their own admission through the Mullins and Johnson affidavits, in the hands of the KIP New York entity, which for some reason apparently has records going back to 1995 related to the employment of Mr. Levin, Mr. Corcoran, and Mr. Randall. So begs the question, which has never really been answered by the defendants, why, if they were totally separate simply a program of the DOE, do they have in their possession and control all of these records? All we're asking is for the chance to sort this out. If the specific entities that are named now should be dismissed from the case, once we look at the documents, we'll dismiss them from the case.
What documents do you think you need that are going to show anything other than what we see? That they were incorporated in 2000 after your students graduated.
There was, prior to the incorporation of the Kip Academy Charter School, there was a program, there was an entity called the Knowledge is Power Program.
It wasn't, the problem I have with what you just said is not I agree with you that from the allegations in the complaint that the program existed, but you just said that the entity existed, and it doesn't seem to me that there are any allegations in the complaint that an entity existed independent of the DOE, which resulted in the creation of the KIP program.
If I could just point, Your Honor, to page 384 of the record, which is the trademark license agreement that, in fact, the KIP Foundation produced, which they say creates the full parameters of the relationship between the KIP Foundation and KIP. The KIP Foundation is the licensor, and they specifically state licensor and its predecessors in interest have used the trademarks KIP, Kip Academy, and Knowledge Power Program in connection with educational services since at least January 1994. All we're asking is for an opportunity to look behind the language in their own agreement that they cite to.
Thank you all. Jane Doe 2 versus KIP, both Jane Doe appeals.
No, I think this is...
We're doing them both together. We're doing the two Jane Doe 2 appeals together.
All right, so...
The motion to re-argue and the regular motion, right?
Plain old motion.
Right, the plain motion.
So in this appeal, Your Honors, we are appealing in Jane Doe 2, another student who was a KIPster at approximately the same time as Jane Doe 1. We're appealing on a motion to re-argue, the lower court reversing themselves. Initially, there was a motion to dismiss. The lower court denied the motions to dismiss with the exception of respondeat superior claims. And then upon a motion to re-argue by the defendants, both sets of defendants, two separate motions to re-argue, the court in a singular order reversed herself. The only basis that the court provided in the decision in order granting the motion to re-argue and then dismissing the claims that she had previously upheld was that she stated that the plaintiff had not submitted any substantive argument to the motion to re-argue. We believe that was an erroneous determination by the court. There was a submission by the plaintiff in opposition to the motion to re-argue. I feel badly if the court didn't feel it was substantive. We tried to make it substantive as best we could. In fact, it was as many pages as the initial motion to re-argue paper submitted by the defendant. And again, and she did not in any way provide a basis as to what she felt she had either missed or misapprehended or gotten wrong the first time around. The argument of the defendants was that the court appeared to have not fully accepted the documentary evidence that was accepted by the court in Jane Doe 3, namely the affidavits of Mullins and Johnson and the Kip Academy Charter, and then also, which we'll get into in the next round, the foundation documents. For the reasons that we believe that Jane Doe 3 should be reversed, we find that even though at this point it's simply speculation as if that was the basis for the court reversing her decision. We believe that that is not adequate grounds for reversing what was actually initially, obviously we felt, a well thought out, well substantiated under the law, and well reasoned initial determination to deny the motions to dismiss. So for that reason, we would, on Jane Doe 2, we would ask this court to reverse the lower court's dismissal of the claims against the individual and KIP individuals and entities, and allow us to proceed to discovery.
Thank you.
Your Honors, with respect to Justice Guerre's order below, it is true that the opinion is short, but it is also true that in the court's recitation of papers reviewed under Sequence 4 and Sequence 5, Sequence 4 is the Kip Academy defendants, my clients, Sequence 5 is the foundation and Michael Feinberg. The court obviously was aware and reviewed the papers submitted on the motions. So again, while the order might be simple, it's clear that she was not persuaded by plaintiff's arguments. So whatever the justification might have been, and by the way, as part of that motion to re-argue, Justice Frischman's order was also submitted to the court. And so it's very possible that she found, and likely that she found that argument by Justice Frischman, his ruling, persuasive, which of course we believe is the proper result in both of these cases. So I do think that the court, was obviously under the impression that the plaintiff's submission was simply inadequate to provide additional argument. And I would say too that if you actually review the papers that plaintiff submitted in opposition, they are largely a recitation of the allegations in the complaint. There's very little additional argument with respect to why Justice Frischman got it wrong, which was defendant's primary argument on the motion to re-argue, relying on Justice Frischman's order. So I guess in that respect, the court was unpersuaded.
Thank you.
Thank you.
Go ahead.
Your Honors, my clients are not a party to the motion to re-argue. We have the 2023 Jane Doe 2, and we're the appellant in that. So would you like me to start that?
Go ahead.
Thank you, Your Honor.
Would you like a minute to reply to respondent?
Yes, may I please?
Yeah.
Thank you, Your Honor.
So make your argument on your appeal now.
Yes, Your Honor. Your Honor, so here we have pretty much the same problems that I discussed with respect to Jane Doe 3. We have a complaint that's self-refuting, okay? And to reiterate, it's conceded in the complaint that during the entirety of the alleged abuse, plaintiffs attending a New York City public school, the so-called KIP program is a New York City Department of Education DOE program, and this is pivotal, and it actually applies to both appeals as well. There's no connection even alleged between the DOE and the foundation defendants, my clients, KIP Foundation and Michael Feinberg. Okay, I'm not arguing that the plaintiff was required to plead specifics, but at the very least, there needs to be an allegation that there was some connection, and it's just not there. What is there is that the foundation was founded for the purpose of supporting the academy, which itself didn't exist until after the alleged abuse in September of 2000. So based upon that, the only possible inference is that the Department of Education would be the only entity that would have a duty to plaintiff. The complaint is equally deficient based upon its theory of liability. It's a purported products liability-based theory, as I pointed out, as plaintiff describes it in the opposition papers, but it's not contingent upon any form of prior notice that my clients had or could have had. So on that basis alone, the complaint is deficient. And then again, we have the extrinsic submissions comprising the documentary evidence as well as the affidavits. And they really, in our view, only make clear what is already apparent from the complaint itself, right? So we have the articles of incorporation from my client, the foundation. We didn't exist until April 2000. We know from the complaint that up until September, plaintiff was still in a DOE program at a DOE school. We have,
So, did the KIP Foundation exist in any way prior to its incorporation?
no, not as far as, there's nothing in the record that would support that.
So with respect to the 3-month overlap that I referenced, running from April of 2000 to the end of the school year in June of 2000, your adversary spoke about programs taking place continuously through September, notwithstanding the end of the school year. Did the foundation have anything to do with that, or does the complaint allege that there was any relationship?
It does not actually, and in fact, annexed to the Kip Academy's charter, okay, is the chancellor letter. And the chancellor letter says, I note, quote, that this application does not involve the conversion of an existing private school. In other words, just as the complaint says, this is all DOE program, DOE school, and the school that forms the sole possible tangential link that my clients could have in this matter, again, didn't exist. It just did not exist. Also, previously, the plaintiff's counsel referenced my client's own trademark license agreement, which uses the word predecessors in interest. That's not dispositive because the default, if I may finish, Your Honor, because the default rule is that there is no successor liability absent any of Schumacher's exceptions, which just aren't in the complaint. So for that reason, the order should be reversed and my client should be dismissed from the action. Thank you, Your Honor.
Thank you.
Your Honor, I'm a little confused. Do I have a rebuttal time?
Yes.
I'll keep it short, I promise. So I want to just take a step back for a minute to remind us all that we're here on the grant of motions to dismiss. And I'm hearing a lot of talk about plaintiff had no proof, that plaintiff didn't demonstrate this. This is a motion to dismiss. And at the crux of what I'm hearing, what this is about is who had a
I think our questions have focused on plaintiff's allegations, not proof.
Yes, Your Honor, I'm actually I'm rebutting more commentary by my colleagues here. The relationship of the KIP program, the Knowledge is Power program, that was operating within, I think it's PS 156, none of us here today are in a position to know the parameters of the relationship between KIP and the Department of Education. It was a unique situation. What's unique here in terms of CVA cases is there is a lot of information that's publicly available about the early days of the Knowledge is Power program. There are books that have been written. There are numerous interviews that have been given by the principals of KIP, David Levin, Michael Feinberg, even Frank Corcoran, even Nolan Highbow, the general counsel for the KIP Foundation, where in their own words, they are saying the Knowledge is Power program, the Kip Academy, the Kip Foundation was created and founded by them starting in 1994. These are their words. We're not making this up out of whole cloth. We didn't pull these entities out of the phone book, if anyone here remembers what a phone book is, that to anybody who had any entity that had the name KIP attached to it. We know that there is this nuclear group of individuals who created the program, who implemented the program, who made promises to the students who were a part of that program, including our client, that Mr. Levin found and hired Mr. Randall. Whether the paperwork was through the DOE, whether it was on the recommendation or certain promises that Mr. Levin meant about the supervision and the implementation of Mr. Randall's music program, we can't possibly know that now. All we know is that we had a child who was in the care of KIP and she was abused. And she wasn't the only child in the care of KIP in those early days who was abused. And all we're asking is for some basic discovery to find out what the interrelationship is and to find out who had a duty to this child when she went to school every day. Thank you.
Thank you.
Thank you, Your Honor. Respectfully, the plaintiff was not in the care of Kip because, again, it says in the complaint that this is a DOE program, DOE school. The theme here really is what this court has said over and over again, which is that even in a motion to dismiss 3211 posture, a plaintiff cannot use discovery as a means of getting around pleading deficiencies. We know predecessor liability has to be pled specifically. It's not there. We know that the plaintiff had to at least allege a connection between the DOE and my client, the foundation, and Mr. Feinberg. I'm not saying specifics. I'm just saying allege it. It's not there. And so the plaintiff cannot be permitted to utilize discovery as a means of curing pleading deficiencies, particularly where the complaint we have here is self-refuting and we have documentary evidence backing that up. So if the court has no further questions, I'm happy to rest on our briefs.
Thank you.
Thank you, Your Honors.
Thank you all. Liberty Mutual versus Marado. Go ahead.
Good afternoon, Your Honors. May it please the court. My name is Michael Kripnick. I'm here on behalf of the appellant defendants, Bronx Medical Health Provider and Burke Physical Therapy. Liberty Mutual failed to establish the specific objective justifications as it must for seeking an EUO of the claimants in this case. Plaintiff relied on the affidavit of its SIU investigator in its attempt to establish these reasons.
Why wasn't that sufficient to establish a basis for an EUO? There were certainly issues raised in the investigation that would suggest questions that should be asked of your clients.
The reason why it was insufficient...
asked of the alleged victims.
So the lower court should have rejected plaintiff's reliance on this affidavit because it was insufficient for two reasons. First, the affidavit was conclusory. It asserted that there were damages inconsistent between the insured vehicle and opposing vehicle, and injuries inconsistent with minimal damage to the insured vehicle, possible jump-in, and to verify facts of the loss. But then it failed to proffer any facts or evidence as to what these inconsistencies were. It did not identify what the inconsistencies were between the vehicles or what the inconsistencies were between the injuries and
Have we ever said you have to do that?
yeah, they have to identify.
Is there a case that says that you have to go into that level of granular detail?
To say that there are inconsistencies, I think
You have an investigator whose job is to investigate and says, the reason why we asked for these people, there was small damage that didn't correspond to the amount of medical treatment they were seeking. There was a question as to jumping and all the things that we normally see in an insurance company investigator affidavit. You're saying there had to be more, and I'm asking you, have we ever said there has to be more than that? Is there a case that says that?
Yes. All right, so
tell me.
First, we would assert that...
No, just tell me the name of the case.
Okay, so the name of the case is Residential Credit Solutions Incorporated v. Good.
And what does that say?
And that says, and this was my second argument, is even if the court were to find that this was not conclusory, it needs to cite to admissible evidence to substantiate what those inconsistencies were. So this says specifically where an affiant's knowledge is based on unidentified and unproduced records.
Well, isn't the minimal damage to the car admissible evidence?
It has to cite some records, either the police report to say that there was minimal damage to the car, or the SIU file, an authenticated SIU file, to say that there was minimal damage to the car, or medical records to say that there was injury, there was actual injuries or lack of injuries.
And where is that?
It isn't there.
What is your authority for saying that? Where are those elements laid out, counsel?
They weren't laid out.
No. What authority? What court authority? What statutory?
Residential Credit Solutions v. Good, where it has to, an affidavit has to cite to admissible evidence.
Yeah, what's the citation?
The citation is, sure, 171 AD 3D 638.
And so that wasn't a no-fault case, was it?
It was not a no-fault case, but
I'm sorry?
it was not a no-fault case, but it still stands for the proposition.
Why are you citing a no-fault case? I don't understand.
Our argument is that the affidavit doesn't comply with rules of evidence to be admissible for the purposes of
No fault is a
summary judgment.
whole animal unto itself, isn't it? With all these specificities and details and everything else.
Sure, but there's still minimal requirements for an affidavit to be admissible for the purposes of procuring summary judgment. This affidavit doesn't cite to any admissible evidence, no medical records, no certified police report,
The only thing that was submitted to get in support of the EOUs as to why they were required, right?
No, it was submitted for purpose of summary judgment, and it was not sufficient. It doesn't cite to any admissible evidence. We don't know what the inconsistencies were. We have no idea, and we have.
But what you're saying is the reason why they weren't entitled to ask for the EOU.
I'm sorry, Your Honor?
Why weren't they entitled to ask for the EOU?
They were entitled to ask for the EOU.
And your clients didn't show.
That's true, but they still have to establish specific objective justifications for the EUO in order to proclaim, to disclaim coverage based on EUO no-show.
Thank you.
Good afternoon, Your Honors. May it please the Court, Nicole Duke from Correa, Conway, and Stifeld for Plaintiff Respondent Liberty Mutual.
Could you address whether there was an adequate showing made as to the necessity for the EUOs?
Yes, Your Honor. The affidavit was provided from our investigator, Kelly Malone Gerard. On top of that, in our very complaint, we alleged and pleaded that there was inconsistent damage to the vehicles, inconsistent injuries as to the level of damage to the vehicles, and the possibility of jump-ins. As to defend...
Have we ever said that an investigator's affidavit has to specify exactly what the inconsistency is or anything like that?
No, Your Honor, not that from the case law that we had.
At least not in support of asking for an EUO, right?
Correct, Your Honor, yes.
Right, that's what this is to say. Here's why, here's an objective reason why I asked for the EUO, correct, right?
Yes, Your Honor, and...
Is the way this works, the investigator's affidavit gets you to being entitled to the EOU. The non-appearance at the EOU gets you to summary judgment.
Correct, Your Honor. So an insurer is entitled to summary judgment, declaring no obligation to pay no fault when a claimant fails to appear for EUO by establishing that there were timely and properly mailed notices of EUOs, which they were timely and properly mailed, as shown on the record, and further that claimant failed to appear for their initial and follow-up EUOs. As to individual defendant Delia Mercado, she failed to appear at 2 EUOs with 3 letters sent. As to defendant Mercado, he failed to appear for 5 EUOs and Santiago for 4 EUOs. Including that, attorneys were involved in Mercado and Santiago where there were actually dates thrown with the attorneys and they rescheduled. So they were fully aware that an EUO was expected of them and there was discussion as to what dates that those individual defendants would be available.
So essentially, this was a fraud investigation.
Yes, Your Honor.
And your adversary says, well, I needed to know more about the fraud. Like, just exactly what were you investigating? Aren't the claimants entitled to seek that information?
Your Honor, that would be done through the EUO as well, so we would be questioning as to the injuries because when we initially sent the letter requesting the EUOs, it was because of inconsistent injuries to the amount of damage that was individual defendants' time to, you
But
know.
they're saying we wanted to know what kind of injury, how bad the injury was, what are you finding that's inconsistent?
Inconsistent as to the level of treatment for this particular level of damage. Bronx Medical had claimed about $14,301, Burke $1,425 of medical treatment for something that appeared to be a low-impact damage case. Further, I would just
I don't know if your declination here was timely. You declined more than 30 days after defendants submitted their NF3 claims, but doesn't it not matter under Unitrin? Isn't that your position, that it doesn't matter under Unitrin because if you don't show up for the EOU, that's a condition precedent to coverage?
Yes, and so individual defendants failed to meet the condition precedent to coverage. Further, just as to plaintiff defendants, argument as to our outstanding discovery. There was no outstanding discovery in this matter. We had entered into a stipulation saying that all discovery was completed. Attorney Michael Krupnick signed off on that stipulation. We had fully responded to discovery as of June 15th of 2023, which is in the record, and no motion was filed to strike the note of issue. After we did file it, the first time that was ever raised as an issue was in defendant's opposition to our motion for summary judgment.
Thank you.
Thank you, Your Honor.
People versus Ward.
Good afternoon, Your Honors. May it please the court. My name is Elizabeth Amanula from Hallwell Schuster, representing Appellant Cisco Ward in conjunction with the Office of the Appellate Defender. For the very first time at trial, a prosecution witness gave surprising and prejudicial testimony that Mr. Ward pointed a gun at her nephew's head, despite never saying this before.
Curative instruction sufficient, and the striking of the testimony.
The trial court initially believed that a mistrial was warranted, and the curative instruction was not sufficient to address the prejudice to Mr. Ward. The prosecutor's supervisor even agreed that a curative instruction likely wasn't sufficient because the image of a man capable of holding a gun to the head of an innocent man.
But the defendant was acquitted on charges of robbery, which would indicate that the jury at least paid attention to the curative instruction, because on those charges where force is an element, he was acquitted on those charges.
That's correct, Your Honor, but they did convict him of attempted assault too, and because the image was so striking of a man that's capable of holding a head, of holding a gun to someone's head, and the attempted assault too, it turned on the issue of justification and whether Mr. Ward felt justified. That sort of image is highly influential to a jury trying to weigh whether this is assault or a justified move in self-defense.
Was this issue preserved?
Yes, this issue was preserved. The law is clear that if a defense counsel has a motion for mistrial denied, they don't need to renew that mistrial motion after a curative instruction.
But at this point, your claim is that the curative instruction wasn't good enough. There wasn't an objection, was there, to what the judge actually told the jury in the curative instruction? Didn't counsel participate in that, in formulation of that instruction?
Yeah, yes, Your Honor, we are not appealing the curative instruction. It's the denial of the mistrial motion. Counsel did agree with the curative instruction, but that was only after the mistrial motion was denied and in an effort to mitigate further prejudice in light of that denial.
Does the speed with which the curative instruction was given make any difference here?
Could you clarify what you mean with the speed, like immediately after?
Well, it happened right away, right?
Yes, yes.
Well, that's what speed is.
Yes, thank you. I think it's significant in the fact that the trial court, after the statement was made, the trial court sua sponte dismissed the jury to discuss how prejudicial and surprising this testimony was.
Was that appropriate?
I believe so, yes, because it was, very surprising and very prejudicial. This was an accessory witness that came in very close to the end of trial that was only supposed to testify about the damage to the vehicle.
Okay. Then what about the curative? Was there a discussion about the curative?
Between the parties, or
yes,
there was a discussion, but this all occurred after the mistrial motion was denied. The defense counsel pressed their motion after a lunch recess, and then they moved on to discussing whether or what remedy they would do rather than a mistrial.
Your request is that if we agreed with you, we would reverse the conviction. Why wouldn't it be sufficient to order a new trial?
Because Mr. Ward already served his sentence, and this happened many years ago, there's case law support for.
But that's for, when we do actually reverse a conviction, that's for relatively minor crimes or offenses. This is not that. I mean, I think we can agree on that.
Yeah, yes, but there are some cases that we cite in our brief that involve, felony convictions. There's a very similar one that involves someone who also served a 4-year sentence for a felony conviction, where the First Department did the remedy that we request. I do see my light. I would like to discuss my second issue if there aren't more questions on this. So turning to the missing witness charge, the prosecution's theory was that Mr. Ward was seeking revenge on the man who had, in the prosecution's words, kicked his butt in a previous fight. The prosecution failed to call this key witness to trial and did not rebut the necessity.
Why wouldn't his testimony be cumulative with all the other witnesses testifying basically to the same thing, surveillance video that was part of the evidence?
Thank you, Your Honor. I have two responses to that. On the first hand, the trial court did not adopt the prosecution's argument that it was cumulative, so that's not properly before this court, but also...
So we couldn't find that?
It was not adversely decided against Mr. Ward. But secondly, it wouldn't be cumulative because
Is there any evidence that Rodriguez saw the defendant's flight from the Burger King?
There's some evidence. Mr. Ward not testified in his statements. He indicated that Mr. Rodriguez followed him, and also he Mr. Soto said that he saw.
The people subpoenaed Rodriguez, didn't they?
Excuse me?
The people subpoenaed Rodriguez, didn't they?
That is not confirmed. The defense counsel says he believes there was a subpoena, but the prosecution never confirms this. The court never confirms this. So there's no true evidence whether or not he was subpoenaed or any evidence that he was unavailable.
Thank you.
Thank you.
May it please the court, Lindsay Richards for the people. Good afternoon, Your Honors. Turning first to defendant's first point regarding...
Was that point preserved?
Judge, it's not with respect to the curative actions that the court took.
But it is as to the mistrial.
Yes, it is. And I think the larger point here, Judge, of course, is that the proof here that the defendant suffered no prejudice as a result of this is the verdict. He was acquitted of every charge relating to that particular incident, other than essentially taking a car or borrowing a car without permission.
What about the assault charge, the attempted assault charge, rather, that doesn't relate to that particular person?
So, Your Honor, the attempted assault in the second degree of which the defendant was convicted relates solely to the incident at the Burger King when he shot Mr. Soto. Which the defendant also admitted to. The jury heard in various different forms admissions from the defendant that he took the gun to that location knowing that the victim would be there. He took the gun and he took a knife. He knew that they would be there. He confronted him on the way out. It also was on video. There's surveillance video from the Burger King. So to assume that the jury was somehow hearing something later about a separate incident that occurred in a different location with completely different victims somehow bled in to the evidence relating to the shooting just doesn't make any sense. And I think that's clear also by the jury's verdict. They clearly followed the court's instructions that they had to disregard that testimony. They clearly did disregard that testimony because they acquitted the defendant of the charges that related to that, especially the robbery charges. With respect, Your Honors, to the second point for the missing witness, this comes back to, this was the defendant's burden. He was the party that was seeking the charge. So the onus was on the defendant to prove all three Gonzalez elements as to why he was entitled to the missing witness charge. He did not do that. He certainly could not show as to why this witness's testimony wouldn't be cumulative, because as Your Honors already touched on, it certainly would have been. This witness was present for the same events as the other two who testified, and anything that this witness could have testified to.
So, and there was video evidence showing the shooting, right? So that evidence is what this witness would have testified to, and the video was shown to the jury.
That is correct, Judge, yes. So there's really nothing more that this particular witness could have added. To the extent that the defendant argued in their brief that this witness could have supported their justification defense. Again, the people were not obligated to call witnesses to support the defense in this case. As the court noted below, the defense was certainly in a position to call this witness for themselves if they believed that he would have supported their justification defense.
Could you address the Miranda warnings, please?
That wasn't an issue that the defense brought up in their brief, Judge, but the defendant was Mirandized before his statement to police, as well as he made 2 videotape statements to assistant district attorneys, and he was Mirandized prior to both of those. All of the Miranda warnings were contained on, all of the statements were recorded, so all of the Miranda warnings were contained on those videos.
Thank you.
Thank you, Judge.
Regarding the prejudice for the mistrial, even though Mr. Ward was acquitted of many of, excuse me, sorry, even though Mr. Ward was acquitted of the charges relating to the minivan, he is still prejudiced by the jury getting this image of him, and these charges are all very related. It was a series of events that occurred in under 7 minutes, and we cite many cases in our brief that make this very clear. We also preserved this issue. Further, I want to disagree with what respondent said. For a missing witness charge, the burden of proving unavailability rests on the party that has control of the witness. The witness is in the control of the party that witness is favorable to, and that favorability relies solely on the relationship between the witness and the parties. Here, the witness was the fiance of a prosecution witness. He had testified in the grand jury, and he had viewed a lineup, so he's clearly...
Even if we were to agree with you on that particular point of availability, you have an issue of it being cumulative.
Yes, so for the cumulative argument, I would disagree and say it isn't cumulative because the issue with the attempted assault too, what it hinged on was the justification, and that turns completely on what the people in the incident believed was happening. The prior fight is a key context to what these people believed was happening, and Mr. Rodriguez was the only person that could give his testimony on that fight as a participant of it, and the jury needed to hear that testimony to be able to weigh whether this was assault or justified self-defense. Also, the cumulative argument, while it was made by the prosecution below, it was not decided adversely to Mr. Ward and is not properly before the court.
Counselor, you did this on a pro bono basis?
That is correct.
The court thanks you and your firm cravat for the time and effort you put into this case. Good job.
Thank you.
Thank you. Thank you both. Ortiz versus Montefiore.
Good afternoon, Your Honors. My name is Thomas Bondi, and may it please the court, I represent Aurora Ortiz and her family, 5 children. I'm here hat in hand today because I understand the frustration of the defendant, the respondent, because it took a long time to get my petition into surrogate's court. But I think their reaction didn't take into account the explanation that I gave as to why there was significant delay.
Counsel, at what point in time was the court apprised that your colleague, Mr. Rosenberg, had passed away. He passed away in 2021.
Yes.
Discovery here began in 2008. There was a settlement conference several months before the passing of
Judge,
Mr.
I'm going to ask you to speak up a little
Oh,
bit.
sorry.
I'm trying very
No,
hard
no,
to.
no, no. I am remiss because I have a low voice and I know it. At what point in time was the court apprised of Mr. Rosenberg's passing, understanding that he passed away in 2021 and he had participated in a settlement conference in May of 2021? Was the court only, did the court only become aware of his passing in 2023?
Yes. Well, yes. There was a complaint made to the court, but there was a judge who didn't hear it because he was transferred. So it didn't happen until 23.
Counsel, when you appeared, did you suggest any alternative remedy, given that things did take a long time? Did you suggest that there might be an appropriate remedy short of dismissal of the complaint that would be appropriate?
Yes.
And what was that?
That I would get a fine. I think of $250 I suggested. And in this case, I would think, and I don't know if you were thinking about imposing costs, but I would waive that. Look, I was sick.
I mean, you would waive costs if you prevailed.
Right.
Go ahead with what you were going to say. Continue with what you were saying. You started saying you were sick.
Yeah, I was sick. I submitted my medical records. I was having a great deal of difficulty with my illnesses, which made me relatively incapacitated. I was nauseous all the time and dizzy.
Did you take any over here? Did you take any steps to have anybody else cover your cases, including this one? I mean, you could understand this case was a 2005 accident brought in 2008, and now we're up to 2023, almost 20 years after the accident, and it's still not done. So my question to you is, what did you do when you know that you're sick and you know that things are happening? Did you do anything to have anybody else cover your cases?
I couldn't because I didn't know of anyone. With the, as you know, we were having a terrible disease going around.
Pandemic, right.
I got RSV, and I also ended up getting COVID. I was a hermit living in New Jersey instead of New York to try to avoid getting sick. I want to point out a couple points, if I can. I see I have a red light, but I have at least...
Finish up.
I'll finish up. On page... I lost my slip of paper. I'm sorry. I just want to point out that the affirmation of counsel for the motion was upon information and belief. My affirmation was
On actual knowledge.
was direct because I had knowledge. And I also wanted to point out that there's an admission in here. Here it is. On page 16, paragraph 26, it says, the matter is unique in that this matter does not concern issues or delays in ordinary discovery.
Okay, counsel, thank you. Thank you.
Thank you, Your Honors. Thank you.
Jonathan Waldauer from Ruben Paternity, Gonzalez, Rizzo, and Kaufman for the respondents. And I'm just going to ask if there's any questions for me.
I have a question.
Yeah. Yes, I will speak in the mic.
I have a question, counsel.
Yes.
So, understanding that this action has been lingering since 2008, and your client, Montefiore?
Montefiore, yes.
Has made a settlement offer back in 2019 of $150,000, which
I think it was
settlement has yet to be finalized. Is that correct?
Yes, it was agreed to, and we are essentially waiting for Medicare and Medicaid final lien letters.
You got those letters finally.
I don't believe we ever got the Medicare final lien. We did get yes. So I think at this point we have now received all of the lien letters.
Understanding that the dismissal of an action is a most severe penalty or sanction, would your client be amenable to a lesser penalty or remedy?
Can you say that? I didn't understand.
Is your client amenable to a remedy other than the dismissal of the action?
I believe that if this case were reinstated, we would finalize the settlement.
Thank you.
Let me ask you one question. Generally, how much does it cost you to do a motion to strike? 2,000, 1,000?
Do you want me to put that on the record?
I would just want you to give me I just want you to just, as a general matter, would you say
Yeah,
like
it takes
maybe
me
$1,000?
between 5 and 10 hours to, maybe 5 hours at most to drive.
5 hours, right? And if, right. And are you outside counsel or inside counsel?
Our office represents Montefiore. We're outside counsel. Yes.
So I would probably like $1,000 max for this motion.
seems-
Okay, thank you.
I mean, you haven't been prejudiced by this delay, except, of course, for the legal fees that have been
That's
incurred.
the position we're taking.
I mean, you haven't suffered any legal prejudice as a result of this delay.
No.
You've held on to what otherwise you would be paying as a settlement.
Correct.
Okay, thank you both.
Thank you.
Can I just bring up one other point, if I may?
Well, you know, you don't have any reply time, but I know that's because you didn't hear the calendar call, so I'll give you a minute.
Thank you. I just want to refer to 2104, CPLR 2104, that for there to be a stipulation, it has to be signed by both parties. And that didn't happen, my signature, until I actually submitted the petition, which is attached to the papers, to the surrogates court, at which time I signed off on the settlement agreement. When I settled the case, it was on the phone with the adjuster, and it was for an amount of money, and it didn't include any of this other stuff that they wanted. But I've been cooperative.
Thank you both. We have your point.
Thank you. Have a good day.
You too. Abiro versus Adams.
Good afternoon. My name is Andrea Biro. I'm one of the appellants in Biro versus Adams. Pretty much we brought this case to the appellate court because our case was erroneously dismissed in the lower courts. One, there was no cross motion whatsoever when it came to this matter. There was only one motion to dismiss. The secondary motion, I guess you can kind of claim it as that, but even that was iffy. There were supporting documents for a motion to dismiss, but no actual motion for a secondary respondent. So there was no cross motion. It was admitted on the transcript, which the appellate court already has. Additionally, the lower court decided to interpret Section 1109, the summary inquiry, which we filed against Eric Adams and DA Alvin Bragg, improperly. They decided to add in their own terminology and basically decided to put their own spin on it to make sure, in a way, like we wouldn't even get to the playing field. One of the things they did was we needed to have specific knowledge. Nowhere in 1109 does it require specific knowledge of the governmental official to have violated their duty, as long as you have knowledge. We proved to them with the supporting evidentiary documents of the notices that were already sent to Adams, as well as CC to Alvin Bragg. So we proved that we had knowledge of the violations that we were raising in the petitions. That was one. Two, according to them, they said we never established that we were taxpayers. There was no requirement in 1109 to establish that. It says as long as 5 citizens and taxpayers bring the summary inquiry to the court, we would be heard. So pretty much there's no way for there was nothing within the parameters of the 1109 within the city charter to basically give us what we needed to establish, which would be deemed as taxpayer. During our argument, offered to rectify any misinformation or missing information. The justice at that time basically said, as long as I'm willing to provide it in the record, as she would not accept any other documentations post-order, the order of show cause that she approved on our initial filings, that it would be fine. I had no problem with it. We were willing to basically, provide whatever information was necessary on the record. We were never given the opportunity. The case was basically shut down halfway through. Majority of the opportunity was given to the respondents to argue their portion of the case. We were given maybe half the time, if that. Additionally, this case was dismissed as a matter of, as if it was argued as a tort or an Article 78. This is not a tort case. This is not an Article 78. This is a summary inquiry, a judicial review for violation of duty, which happened in both cases. We raised both of them properly within our petitions. We made sure that the justices knew that the summary inquiry was brought against Eric Adams, our mayor, for violation of oath of office, as well as various other violations. On top of that, we brought in Alvin Bragg because of the fact that every single notice that we sent to Eric Adams, he was CC'd. And according to 18 U.S.C. 4, if you are made aware of a crime, you have to initiate an investigation into that crime. If you cannot, you need to forward it to either a party or an office that is willing to investigate and or can remedy it. None of that happened from the DA's office. We were forced to bring him into the summary inquiry. We're under the 18 U.S.C. 4. So pretty much, we made sure that our petitions had all of that. We attached every exhibit into the lower court. We made sure that we proved to them, according to the lower justice, she reviewed and read our documentation. However, upon reviewing her dismissal, we're not sure which evidence or documentation she reviewed. Most of the information in her dismissal sided with the respondents and the fact that we didn't meet the threshold for CAR, which once again was never established within the city charter for section 1109 as a requirement. However, upon reviewing that, we did meet it. And then on top of that, then to say, even though we didn't meet the threshold for CAR, she never even entertained to review CAR. So if she never reviewed it, how do we know we never met the thresholds for it? And so there was, once again, there was various information there. So there was a lot of misapplying, misinterpretation, misuse of authority when it came to the things that were challenging. They kept arguing that based on the executive laws that are already in place, that our mayor had every right to issue the executive orders and emergency executive orders that he did. Nowhere in our documents did we ever challenge the fact that our mayor had the authority to write an executive order or to write an emergency executive order. That is part of his mayoral duties. That is part of his powers. He's allowed to write them. He's allowed to enact them. What he's not allowed to do is then direct enforcement as a matter of law upon the men and women of New York to then, to further then use 3-letter agencies and or other departments of New York City to then further that enforcement of it. That's where he overstepped his authority, and that's what we were challenging. And
Thank you. Thank you.
Your Honor, my name is Amanda Abata, and I represent the mayor, Mayor Adams. In order to just sort of simplify this, I would ask to just take any questions from the panel if you have any for me. Otherwise, I'll rest on the brief.
So your motion, you made a motion to dismiss, but Defendant Bragg did not, correct?
We made a motion to dismiss, and I leave it to him, I guess, to speak to, I guess, the procedural posture in which the DA brought his motion. there are no further questions, I will rest on the brief. Thank you so much.
Thank you both. People versus Richberg.
He wasn't here.
You didn't ask for time, but go ahead.
No, she's talking.
Are you talking to him?
You didn't ask for time at the calendar call. I'll give you a couple of minutes.
My apologies, Your Honor. May it please the court, Victor Oles for respondent, Alvin Bragg. Your Honor, I just wish to make 3 quick points. First, Justice Kim's decision and order should be affirmed because the appellants have neglected to establish that they meet the standing requirement under Section 1109. They had multiple opportunities to do that. They failed to do that. There are only 6 categories of individuals who can bring an 1109 summary inquiry. In order to do that, one has to establish that they are taxpayers. And they did not do that in this instance. Secondly, Your Honor, this case really should be affirmed because on the grounds of mootness. The initial order that was issued by Mayor Adams in March 12th of 2020 was effectively rescinded by Mayor Adams on March 7th, 2022. And as this court and many other courts have held, when there is no live viable issue, the matter is moot. There is nothing to indicate that this issue will resurface. The Key to the City program has effectively been rescinded. In fact, it was rescinded 7 months before the petitioners filed their petition on October 27th of 2022. And lastly, Your Honor, even had the appellants satisfied, may I just finish my sentence, Your Honor?
Go ahead.
Even had the appellant satisfied the standing and requirement, and this had not been moot, what they are urging upon the court doesn't exist. They are claiming that the district attorney has a duty to investigate. Nowhere is that found in Section 700 of the New York County law. The obligation is to prosecute, not to investigate. And so for those reasons, we would urge that the decision of Justice Kim be affirmed.
Thank you. Thank you all.
Thank you.
You want a minute to respond to him? Go ahead.
Thank you for giving me the minute to respond to the DA's statements for oral argument. One, once again, I would like to address the fact that Mr. Olds is presenting the case as if it was an Article 78. We're not, once again, contesting the policy. We never contested the policy. That's where an Article 78 would thrive, contesting the policy, and at that point, rescinding the emergency executive order would then make that contest moot. However, we are, at this point, contesting the authority of even enacting that original emergency executive order. That's one. Two, according to Section 1109, and I quote, right? It says a summary inquiry into any alleged violation or neglect of duty in relation to property, government, or affairs of the city may be conducted under an order to be made by any justice of the Supreme Court in the 1st, 2nd, or 11th Judicial District on application of the mayor, the comptroller, the public advocate, any 5 council members, the commissioner of investigations, or any 5 citizens who are taxpayers, supported by an affidavit to the effect that one or more officers, employees, or other persons herein named have knowledge, information, concerns of such alleged violations or neglect of duty. Nowhere in 1109 does it say that we need to, at any point, establish anything other than filing what we need to. All of our documentations were accepted by the court, therefore the assumption lied within the court that we have met all the criteria. Once again, at oral arguments, I presented to provide any missing information if need be. The opportunity was never presented and we were cut off, okay? However, the district attorney was given a lot more leniency than we were ever provided as a pro se litigant, including not even accepting our affidavits of service for their documents that we have served them, okay? We request as petitioners for this summary inquiry to be rescinded back to the Supreme Court and for it to continue at this point. We have jumped through enough hurdles as to prove that there was overstepping of authority when it comes to any regarding the mayoral duties, as well as Alvin Bragg, who may not have under New York County laws, but under federal laws did violate their duty. And according to the oath of office taken by that lovely
Thank you.
DA's office, he did violate it.
Thank you. Thank you all. People versus Richberg.
Good afternoon, Your Honors. Paris DeYoung of the Legal Aid Society here on behalf of Appellant Mr. Tyrese Richberg. In no way diminishing the severity of the underlying offense in this case for a 20-year-old father who willingly admitted guilt in the instant offense and received a far harsher punishment than his co-defendant for the same conduct, imposing the maximum PRS term here was excessive. Now, there are several...
Co-defendant didn't jump bail, right?
That is correct, Your Honor. So my client did abscond for 5 months during the pendency of his case, but that does not, in our view, justify this notable discrepancy, and there's a couple of reasons for that. One is that my opponent's actually mistaken in their brief in saying that my client was facing mandatory consecutive sentencing if he had been convicted of the bail jumping. That's actually not the case. The relevant subsection is 7025, subsection 2C. Okay. And under that subsection, consecutive sentencing is only mandatory if the defendant receives indeterminate sentences on both. That obviously didn't happen here. It's very likely my client would have gotten concurrent sentences. And in any event, we acknowledge that absconding is an act that the other co-defendant did not commit, but we're asking for a very modest reduction in PRS here. And if Your Honors were to grant that, he still would have served a significantly longer sentence than his co-defendant. I also want to just point out when it comes to the co-defendant, my opponent highlights in trying to distinguish my client.
Is more, the PRS can be reduced, isn't it?
It could be, yes. Under less is more, it could be administratively reduced, depending on how well he does while he's out on PRS. But the legislature, in passing that act, did nothing to curtail this court's power to reduce a sentence as excessive in the first instance. None of that changes the fact that he shouldn't have received the maximum here for a number of reasons. And one of the things I just wanted to briefly go back to when it comes to the co-defendant, because I think there's strong case law suggesting that for the same behavior, two individuals should be sentenced similarly. My opponent tries to highlight that my client had a JD adjudication when he was 15 and a YO adjudication when he was 18. That YO, obviously neither of these are criminal convictions. They shouldn't be treated as such, and they should be given very little weight by this court. But that YO adjudication was for criminal possession of marijuana in the 4th degree. That penal law was actually repealed under the Marijuana Regulation and Taxation Act. Anyone who has a criminal conviction for that offense had it automatically expunged off their record. Moreover, the co-defendant actually was on probation at the time that he pled guilty, which suggests that he had more of a criminal record than my client did. That was the minutes that I submitted plea minutes to Your Honors last week. I have additional copies here if you'd like to look at it. He was on probation. He also had an outstanding probation violation unrelated to this offense. The other factor I'd like to just briefly highlight, Your Honors, is my client's continued admission of guilt. My opponent tries to make several very bold claims that my client never admitted guilt, didn't accept responsibility, was not helpful to the police. If you all take a look at the People's Automatic Disclosure Form that I submitted to the court, my client not only identified himself in the surveillance footage that my opponent refers in their brief on page 18 as overwhelming evidence of my client's guilt, he also identified the parties who were there, his friends, other people in the video. There's no reason to think with how forthcoming he was being that he was in any way being withholding or somehow didn't admit guilt. He also pled guilty in the instant offense. He told the Department of Probation that he did it. And defense counsel put on the record that he was forthcoming and helpful with the Department of Probation. Lastly, Your Honors, I just very briefly want to address my client's relationship with his family. My opponent makes several attempts to denigrate my client's character, and at one point refers to my client as a...
push back against your point about the co-defendant because this crime was recorded on video, and they say it may very well be that the video showed that your client was more culpable than the co-defendant.
Your Honor, that to adopt that is to engage in pure speculation, which would be outside the bounds of what this court is doing. I also want to note that my opponent in their brief makes no substantive attempt to distinguish their behavior. They actually quote directly the indictment, and they say at one point, Louis Joyce and my client, violently attacked this man. They don't have any evidence to suggest that these two individuals were in any way differently engaged. There was a third party, I also want to note, who had a knife.
There were 4 perpetrators involved in this, weren't there?
There were several perpetrators.
One of whom stabbed the victim.
That's correct, and he went unapprehended. They were never able to actually find him, and based on the statement that my client gave, the men who were involved were not closely related. He didn't have a close relationship with that individual. And to my knowledge, he was never, the man who had the knife, who did the primary damage to the complainant, was never
Thank you.
found.
Good afternoon, Your Honors. Andrew Loizides appearing for the respondent. May it please the court. Your Honors, the defendant's post-release supervision was not excessive, considering that the defendant was involved in a gang.
What was the reason for the difference between the sentences between the co-defendant and the defendant? One received probation and he got incarceration, PRS.
Well, put simply, Your Honor, our defendant here is a bail jumper. He didn't appear for court for 5.
Was this plea to cover the bail jumping as well?
Yes, Your Honor. In fact, and as my adversary stated, that he could have possibly, there's a possibility he could have received more jail
Faced a
time.
mandatory consecutive 3.5 to 7 on that.
Yes, Your Honor, that's correct. So
He was never prosecuted on the bail jumping, so this plea covered it.
that's correct, Your Honor. Yes. So again, considering that the defendant was a bail jumper, was involved in a gang-style assault, and as Your Honor pointed out earlier before, that less is more can eventually reduce his probation as long as he is compliant. The defendant's post-release supervision is not excessive, and unless Your Honors have any further questions for me, I respectfully submit the rest of my brief. Thank you.
Your Honors, I just want to start by correcting one misstatement in my opponent's brief that Your Honor just brought up. He was not facing mandatory consecutive sentences with the bail jumping.
Cover the bail jumping?
It did cover the bail jumping.
It did or did not? I didn't catch that.
It did, yes. It did cover the bail
If he was
jumping.
convicted of this and he was
Yes.
convicted of that, the bail jumping would be mandatory consecutive time, wouldn't it?
That's not correct, actually, Your Honor. No, under Penal Law 70.25, subsection 2C, I actually have it printed out if Your Honors would like to look at it. The only time that those two things have to be run consecutive is when there's an indeterminate sentence on both. I know that sounds a little bit counterintuitive, but I've thoroughly researched it, can confirm he would have likely gotten concurrent time. Lastly, Your Honors, I just...
But we can all agree that it covered both charges.
It did, yes, that's in the minutes, that's correct. I also just want to highlight, my opponent says that he was involved in a gang assault, so was his co-defendant, so that doesn't do anything to distinguish these two gentlemen. Lastly, Your Honors, I would be remiss if I didn't talk about the fact that my opponent makes these egregious attempts to denigrate my client's character. He referred to him in the brief as a deadbeat dad, which was not only grossly inappropriate to be raising, but also flatly untrue. As my opponent notes in their brief, there was no child support order. There's still no child support order. My client is a loving and supportive daughter, and that relationship with his daughter, as well as with his siblings, who he is very close with, who have raised him since he was orphaned at age 11, also justify a reduction here. Thank you.
Thank you.
Thank you, you too.
So Friday, Donald and I are gonna switch. He's gonna take the 8, I'll be the 7.
Okay, sounds good.
Anything else?
No, I'm good.
See you bright and early tomorrow.
Yes, sir.